no consistency.
Not that that's true.
Strict results where they use rational basis, right?
Yeah.
Okay, welcome back, guys. So I apologize in advance. I had a tooth extracted this morning. This is actually crazy. I had a baby tooth until this morning. I didn't. Somehow, it's true. I swear,
You had a what?
a baby tooth until this morning.
Oh, I thought you said you had a baby. What? You had a day, man.
Baby tooth, baby. It never fell out, and no one found out about this until I was like 25. They did an X-ray. They said, "Huh, there's a tooth above your tooth." I malpracticed my child dentist. I don't know. So I don't know. So in other words, it was just hanging there, and over the weekend it chipped. So I had to get it removed this morning. So my mouth hurts a little bit, but I think I'll be okay. They put like a temporary crown in, so I have this contraption in my mouth. So it's somewhat impeding my talking, but I think I'll be okay. Just a little inflammation, but if I get weird, I'll let you know. But I think I'm okay.
As of last week, you were still teething.
What's that?
As of last week, you were still teething.
I'm still a baby, aren't I? Okie doke. We have only one class. So one class after today. We have a review session coming up a week from today. I will be going over the spring 2018 final exam. I haven't decided question 1 or 2 yet. I'm not sure. I'll figure out later. We'll do one of the questions. So if you want to do another practice exam over the next week, I would suggest you do the spring 2018 exam. Okay? And at this point, I think I've met with all of you to go over your midterms. I do enjoy it. I learn a lot from you. You're all very rich people with a lot of experience. So I'm always grateful to meet with you. Are there any questions or things on your mind? Anything on your mind? No? Okay, we'll start. So every semester, I like to give a recent case. I do this for a host of reasons. One reason is it's recent, and you probably remember reading about it and hearing about it in the news, and you're probably familiar with it, right? So there are pros and cons to that. The pro is you're familiar with it. It's not something abstract like seizing of steel mills or locking people up during the Civil War, right? They're cases you can relate to. But the con is you can relate to it. And very often when you have a issue that's long ago dead, you can analyze it in somewhat objective fashion, right? I don't think any of us actually care that Lincoln suspended habeas corpus in the Civil War. I mean, it's a nice thing to talk about, but it doesn't actually affect any of us on a daily basis, right? I don't think any of you care that the Legal Tender Act was declared unconstitutional, right? Right? We can talk about the Commerce Clause, but you don't care. I don't think any of you actually care that Farmer Filburn couldn't grow a couple extra bushels of wheat. I just don't think you care. But with the recent cases, you do care. Okay, I don't really care, right? But with the recent cases, you care. So when I first started teaching, I think my first term I did a case called Zivotofsky v. Kerry, which I don't have in the book anymore. But that involved whether Congress passed a law saying that if you were born in Jerusalem, your passport would say Israel. And that was a very big case. And then I shifted to Noel Canning, which was a very huge case at the time, but somewhat subsided in salience. And in the last 2 or 3 years, I think I've done a Bergefeld, the gay marriage case. And even that case, too, as important as it's subsided, just isn't as salient in our culture as it was a few years ago. In fact, I used to spend an entire class in Bergefell. I assigned the entire opinion, over 100 pages. You guys don't have that anymore. So I picked Trump against Hawaii this year. Maybe I'll teach next year or not. I'm not sure yet. But I picked it because, again, it's salient and it's live. But I think it also helps teach another lesson that when we're looking at legal issues, we can sometimes separate ourselves from the moment and look at an issue in the abstract, as hard as that may be. So I didn't give you the full opinion. I gave you a 30-page excerpt of it, which I think does go a long way to explaining the facts and has most of the things in there. But it does have a pretty broad sweep of the case. And the other reason why I give these sort of new cases at the end of the semester is I don't know whether this case will ever make into the textbook. Randy and I, we have a supplement which I don't make you buy, but we have a policy which I think is a good rule where we wait a couple years after a case is decided before we put it into the textbook to see if it's still as significant 4 or 5 years later to warrant a place in the casebook. There's some casebooks you buy that change every 3 years radically, and I think that's a little it rushes because you don't know what's important yet, right? When something's before you, it's like, oh my God, this is so important. It's like, oh, no one talks about it anymore, right? And just use the travel ban as an example. This was a big deal like 4 or 5 months ago. It's in effect now. You don't even hear about it, right? There's zero attention. It's been in effect now for almost a year, 11 months. Zero attention on it. The waiver thing that Justice Breyer made a big deal about, it doesn't even matter anymore. It's like not even litigated, right? All the big lawyers who litigated the travel ban, they're not litigating the waiver issue. They could, but they dropped off the case, right? This big thing, oh my God, these waivers show this is a bad... I talked to one of the lawyers who worked for Hogan Lovells, the main law firm that argued this case at the court. He said, yeah, we're not doing that case anymore. We just dropped it. Move on to the next one. So, again, I don't know how important this case will be in 5 years, 10 years. I don't know. It might just be a blip in the radar. Maybe it'll be important. Maybe it won't be. But I like teaching this because we don't yet have a sense of scale of where this case fits. So, anyway, I don't know. I've lectured on this case before. If any of you came to our lunchtime event about an hour ago, maybe you heard me talk about it, but we'll have a good discussion tonight. Now, any case before we get started? Okay. So this case, again, the reason why I put it at the end of the semester, it unites several different strands of our thought, right? So first off, it talks about the executive power, which we discussed fairly early on in the semester when we discussed Korematsu and the Japanese detention cases, and Youngstown as well. It also incorporates a topic that we only covered last class very briefly, which is the Establishment Clause. We did the Ten Commandments cases, McCreary County and Van Orden. And I rushed them a little bit, knowing that we would come back to it in this case in a little bit more depth. So I had a little fallback for that one. And it also involves something that I don't think you've been exposed to yet, which is statutory interpretation, right? How to read a statute, right? All you've been doing so far is common law stuff, and in this class, constitutional stuff. But most law that you're ever going to do in practice is you're reading statutes. Acts passed by the state legislature, acts passed by Congress, perhaps regulations drafted by agencies. And there's a certain a skill in reading statutes. And this case has the added element of how to read statutes to avoid constitutional problems. What do I mean by that? If we presume that the federal government has certain powers, and they pass a statute that can be construed one way and can be construed another way, option A is it enables the government to do what it wants to do, and option B is it limits the government's powers, right? Which reading is preferred? And I think this case illustrates the avoidance canon, that you read the statute to avoid limiting on the government's power, which sort of relates to how the court in the Obamacare case read the Affordable Care Act, although in the opposite fashion, because they upheld the statute. All right, so any questions on that? Just general frame. All right, let me give you some background on this case, and I'll lecture a bit, but then I'll start calling people in a few minutes. So I want to start by referencing a case I think I've mentioned before, which is Texas versus Johnson, right? This is the flag burning case, right? Before there was kneeling, there was burning, right? And you actually had Texas try and throw a guy in jail for burning an American flag. And he burned the flag outside of the Republican National Convention in Dallas back in '84. And he was prosecuted and convicted in a Texas court. The case went to the Supreme Court, and the court ruled for him by a 5-4 vote. They reversed the conviction. And actually, the deciding vote in that case was Justice Scalia. Right? He had been on the court maybe 1 or 2 years at that point. And he would often come back to this vote as an example where his vote went one way when his politics would almost certainly go the other way. And he once said, I'll read you this quote, he said, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag. But I am not king," he said. And he thought that his answer was compelled by the First Amendment. And the reason why I bring this up is, actually someone asked me this in our review session yesterday, so I wanted to address it as well for the entire class. The question was just like, how do you separate your political beliefs from your legal judgments? And let me tell you, it's really hard. I don't know that I know I'm not perfect, and I know I conflate the two all the time. But one way that you can check yourself, like a gut check, is, do you ever come across a case where you think, wow, that's a really good idea, but it's illegal. Can't do it. It's unconstitutional. Or do you ever come across a case where you said, oh my God, that is such a terrible policy, but yeah, the government can do it, right? If the answer is yes, then you are probably engaging in some sort of reasoning. And if the answer is no, that is your political beliefs line up with your legal beliefs 100% of the time, then you can reassess yourself and reevaluate. And I think on the Supreme Court, all 9 justices, I believe this, have the sorts of cases in the first category where they hate the result, but they feel compelled to vote that way because of the law. Not always, but I do think at times all 9 justices do this. I mentioned the Scalia case. I think for the liberal justices, it's death penalty. I think some of the justices think that the death penalty is in all attributes unconstitutional. But the court gets countless death penalty stay applications on a daily basis. And those are sometimes 9-0.
When I was reading this case, my mind started wondering, I was curious as to when self-preservation trumps the law.
What do you mean self-preservation?
Like if the Church of England were going to come over and said they're going to kill everybody in America and they start coming over, do we analyze it like this, whether or not we're, infringing on their, or adopting some sort of religion or infringing on their religious rights, or do we say we don't care, you're coming to kill everybody, we're going to fight back, I'll let you come over?
Are you talking about the court or the executive branch? I'm not sure what you're referring to.
Well, I guess both, right?
Well, let me go into the case, and I think I might come back to your point in a few minutes, okay? So let me just walk through some of the facts. And again, I'm sure most of you are familiar with at least some of the facts I'm going to give. So in December of 2015, at that point, Donald Trump was a candidate for president. And he called for a, quote, total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. And that was a statement that he put on his website and stayed up there for quite some time, I think past the election. Over the next few months, President Trump announced a different position. He said he would engage what he called extreme vetting of people entering the United States from certain territories. Or did he? One of the difficulties of writing and covering the current presidency is the words don't always make sense. It's often very difficult to figure exactly what he's getting at. And he can often contradict himself within the same sentence. So in one interview in July 2016, he told Leslie Stahl in 60 Minutes, you can call it whatever you want, but we'll call it territories. So is it actually a repudiation, or was he sticking back to his old policy? But then about a week later, in Meet the Press, he said, I'm talking territory instead of Muslim. Did he really mean it, or was he lying? What do the fact checkers think? The reason why these statements are important is one of the issues in the travel ban case was the question of animus and purpose, and trying to ascertain the purpose of the actor. Now, these were all campaign statements, okay? Following the inauguration, about 1 week after the inauguration, the president signed the first iteration of his travel ban. There will be 3 different versions. And there was a statement made by former Mayor Giuliani, on a cable news program where he seems to suggest that he was asked to find a legal way to accomplish the president's purpose. Now, was that to accomplish the Muslim ban or some sort of entry ban for territories? What exactly was it? Again, you're dealing with statements made on TV. Okay? But then it goes to the courts. And I'll walk you through at least the beginning of this, and I'll start calling on people. So the very first iteration of the travel ban was a disaster. It was a mess. It was signed 1 week after the inauguration. It did not go through the level of vetting and review that it should have. It was announced on a Friday afternoon without any advance notice. And the first iteration of the travel ban, I'll call it Travel Ban 1.0, said that for 90 days, certain aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, Yemen, seven countries, that their entry would be deemed detrimental to American interests. They'd be denied entry. It also shut down the refugee admission program for 120 days. Syrian refugees in particular would be denied entry indefinitely. Okay? The immediate aftermath of this policy was that people who were in the air, right, flying across the Atlantic or Pacific to get to the United States, when their planes took off, they were cleared to enter. While they were in the air, the policy changed such that they would not be allowed to enter the country. And the effect is when they got to the customs office, if you ever go to an international airport, you've got through customs. By the way, you may not know this. When you get to an airport and you go through customs, you are not on U.S. soil yet, right? You are not on U.S. soil till you clear customs. You're in this weird middle region. Just so if you ever travel, you know the answer. You don't get lawyers. It's actually a very bizarre place. People are getting locked up and detained at airports. And they're actually holding cells in most airports and getting locked up and detained. In fact, many of these people were actually green card holders, what are called lawful permanent residents, who have a statutory right to enter the United States. The executive order, I don't think, should have applied to them, but there was no guidance. There was no strategy. It was a disaster. So in the immediate aftermath, you had judges issuing what are called writs of habeas corpus, which, same with Lincoln, right? Show me the body, right? Deliver the body. And judges in New York and Boston and elsewhere, where they're big international airports, ordered the release of people held in these airports from these holding cells. But that was only the first round of the litigation. Shortly thereafter, the Washington Attorney General filed a lawsuit in federal court in Seattle. And he argued that the travel ban was illegal. And he sought what sometimes is called a nationwide injunction. I also call it a universal injunction to halt the enforcement of the travel ban, not just in Seattle, but across the country, in every port of entry. The judge entered a temporary restraining order blocking the enforcement of the travel ban. And back in January of 2017, I was a very busy person. I wrote about this stuff at great length, and I wasted way too much time, and I regret it in hindsight, but I did a lot of work on it. And the initial order from the district judge in Seattle had about 2 sentences of analysis. It didn't say what clause of the Constitution violated, really. Didn't really give any accounting of the statutory framework. She said, this is unconstitutional, stop it right now. Not nearly enough analysis to halt a policy of this scale. At that point, the government tried appealing the case to the Ninth Circuit. Now, you may not know this, but generally with a temporary restraining order, you can't really appeal. You can only seek what's called mandamus, like for Marbury, right? You can seek mandamus to stop it, and that's very hard. And the Ninth Circuit actually found the travel ban was unconstitutional under the Due Process Clause, which was a totally bogus argument. You saw nothing in the case you read about the Due Process Clause. It was an argument that just disappeared as quickly as it began, right? After the Ninth Circuit ruled against the Trump administration, they decided instead of appealing to the Supreme Court, they withdrew the policy. And they said they would start again. About 2 months later, in March, the Trump administration announced the second version of the travel ban, and called 2.0. And it made a number of changes to the policy. Okay, one of the changes was green card holders were not denied entry. I think that was a very important change because they have a statutory right to enter. Iraq was removed from the list because it said Iraq would now cooperate with us concerning terrorism. Now, the justification for the policy also shifted. Instead of saying that these countries were likely to ship terrorists to the United States, the focus changed. Now the focus was these countries do not adequately share information needed to vet possible terrorists. And that was one of the first clues that the administration was getting its act together and wasn't going to be doing the sort of back of the cocktail napkin approach to executive orders. Right? That these countries didn't have adequate screening mechanisms for their aliens. Okay? Once again, Travel Ban 2.0 was halted in federal courts, this time in Hawaii and Maryland and elsewhere. And these judges entered nationwide injunctions. One or two judges actually upheld Travel Ban 2.0, but when you have a nationwide injunction, which basically applies to the entirety of the world, it doesn't matter if one or two judges uphold it. So long as one judge declares it unlawful, nothing else matters. This time the judges moved past the due process argument, and they moved on to one of two grounds: a statutory argument and a constitutional argument. I'll go into the statutory and the constitutional in a few minutes when we get to the case, but the court in which one was it? I think the court in Hawaii ruled on somewhat more narrow statutory grounds, whereas the court in Maryland went, I might be flipping them, it's not important. By the way, no one remembers district court judges. I mean that sincerely, right? These judges think that they're kings of the world until they get appealed. No one remembers them ever again. So one of the district court judges went Establishment Clause, one of them went to the statutory issue. Again, the courts of appeals ruled against President Trump, Ninth Circuit and the Fourth Circuit, but then got appealed to the Supreme Court. And this was the first signal that something was up. The Supreme Court ruled in favor of the Trump administration in part, and they went like this. They sort of split the baby. They said that if an alien has a special relationship to an American person, what's called bona fide relationship, right? Bona fide, person of value, right? That person will be allowed to enter. But if an alien lacks a bona fide relationship with the United States person, they would be denied entry, right? So at that point, the court allowed a huge chunk of the travel ban to go into effect. And I wrote about this at the time saying, guys, well, generally when the Supreme Court rules that something can go into effect temporarily while appeals pending, that's a very good signal that ultimately the court will rule that the entire policy can go into effect down the road. No one listens to me. Okay. I took a lot of crap on this. You think birthright citizenship was bad? This was over a course of a year. Birthright citizenship lasts like for a day or two, right? We go forward. Travel Ban 2.0 was never meant to be final either. It was an interim policy that lasted in duration of 90 days. The 90 days ran their clock, and then we got the Travel Ban 3.0, which is called a proclamation. Now, what's the difference between an executive order and a proclamation? Absolutely nothing. The only difference is the statute actually says that you have to have a proclamation or declaration, right? The statute says proclamation. That's the only difference I can think of. Actually, but there's no difference in an executive order, proclamation, and a tweet. It really makes no difference. But then in September of last year, of 2017, the president issues the third executive order, called 3.0. There were now 8 countries in the list. Chad was added, as well as Venezuela and North Korea. Okay. Now, the North Korea one wasn't particularly meaningful because, as you might guess, there are not many people coming to the United States from North Korea. And the Venezuela one was also fairly limited. It only applied to certain diplomats and the government and their families. So at bottom, you still had predominantly Muslim nations who were found that they failed to provide adequate information sharing with the United States. One of the difference, though, is that this executive order was accompanied by a fairly lengthy report from Homeland Security explaining how they came to the result they did. Not all the research was there, but they had a report. Okay. Fast forward. Once again, these policies were challenged, and federal courts in Hawaii and Maryland declared them unlawful. And once again, the Fourth and Ninth Circuit Courts of Appeals declared the policies unlawful, right? You're sensing a pattern, right? It replayed itself. It was like this slow motion train. We all knew where it was going. But then the government sought a stay from the Supreme Court. And the Supreme Court, in an opinion, unsigned opinion, but in an opinion, allowed the entirety of Travel Ban 3.0 to go into effect. So in December of 2017, just about a year ago, the court allowed the entirety of the policy to run into effect. At this point, I was screaming as loud as anyone would listen to me that the court's going to uphold this, right? On the Roberts Court, when the court allows a policy to go into effect in its entirety on a temporary basis, that is a sure fire signal that the court will allow it to go into effect on a permanent basis after it's argued and briefed. So by the time the case was argued in March of 2018, 6 months ago, I was at the oral argument. And it became pretty clear from where I was sitting that there were at least 5 votes, maybe more, to rule that the travel ban was constitutional. I was also at the court at the very end of the term. And I was in the court when this case was announced. Unfortunately, the audio is not yet available. But Chief Justice Roberts read the majority opinion, and Justice Sotomayor took the not unusual but not typical step of reading her dissent from the bench. And usually a judge reads a dissent from the bench when they want to make a statement about it, and it was pretty pointed. And you don't get this in the writing, but the tone of their voice was one of Justice Sotomayor's voice was one of anger. And the way, if you notice in the opinion, she said Trump, not President Trump, but just Trump. And the way she said Trump at the hearing and the court was, I hadn't heard something like that before. But there was a lot of emotion in this case that I don't think you see in most cases we decide. So I'm giving you the ending, but the court upheld it 5-4 vote. The Breyer and Kagan opinion was kind of narrow, but I'll call it 5-4, make it easier. And that's where we are today. So any questions on the facts? I try to give as much as I can, but I can't do justice to everything. So any questions on the basic? Yeah, mine.
How come Trump's prior statements during his campaign, how come that come into court?
How can it or can't it?
How could it be?
We will get there, I promise. We'll answer that question. But any questions on the general facts, not the analysis? I tried to avoid the... Hey, do you want your hand up? Yeah, you shut.
Somebody should answer this.
Okay, yeah, Clay.
That's probably elementary. How can the Ninth Circuit overrule an executive order?
Okay. So the question was, how can the Ninth Circuit overrule an executive order? What is an executive order? I don't think I've ever actually answered that question before. The president has certain powers, right? The president gets power from the Constitution, and the president gets power from a statute. Right? Those are the two sources of statute, right? So all an executive order is an exercise of the president's power. He says, I have this power from the statute, and I have this power from the Constitution. Therefore, I'm instructing my subordinates, the Secretary of Homeland Security, to do X, Y, and Z. Think of Youngstown, right? Where President Truman ordered his Secretary of Commerce, Sawyer, to take over the steel mills. And the Supreme Court said in the Youngstown case that this executive order is without authority, right? The president does not have the authority to instruct his subordinate to take over the steel mill. So when a court reviews an executive order, what they're asking for is, does the president have the authority to do X, whatever X happens to be? So there's nothing problematic with a court ruling that an executive order is unconstitutional. There were some standing and justiciability issues about whether, because generally, taking a step back, if a visa is denied, right, maybe do immigration, I think, are there any immigration law people here, people working in law firms, immigration? Who's your hand? Anyway, generally, if your visa is denied, you're out of luck. You can't go to court, right? There are certain doctrines of what are called consular non-reviewability, where denials of visa to enter the United States, if they're denied, you can't go to federal court. So there was a lot of discussion on whether you can even sue over this. I don't need to bore you on this because it's not important, but there was, I think, a fairly credible argument that none of these cases should even go to court because you have no right to enter. They call it a privilege, as they say. Again, for green card holders, different story because they do have a statutory right to enter. I have to make a very big stress about that. Any other questions on the facts? All right, so, oh yeah, I'm sorry, George. Yeah.
You mentioned that when one of the courts declares a universal injunction,
Yeah.
no matter if any other court says otherwise, that holds
Yeah.
on any subject?
All right, let me answer a question. So, you may have read about in the news or heard on TV or whatever the concept of a nationwide injunction, and I think Justice Thomas alludes to it in his concurring opinion here. Generally, a court only has authority over the people before him, right? So, Smith sues Bob, right, and the court issues a judgment that binds Smith and Bob. It doesn't affect Sally. Right? We discussed this. Sally might follow the case as a matter of precedent. But what happens when the defendant is the federal government, right? And you sue the Secretary of Homeland Security, you sue the president. The president is not limited to Washington, D.C., right? The president and the secretary exercise authority around the world at every port of entry. So it's not unusual that when an injunction goes against the president or secretary, you can't enjoin the president, I don't think you can, but let's say the secretary. When you enjoin the secretary, they generally tend to follow that in each place they exist. But the difference is the plaintiffs, right? These cases were brought on behalf of certain groups of plaintiffs, right? They may have been the International Refugee Assistance Project, IRAP. They may have been people who were trying to get into Hawaii, but they're applying to certain groups of plaintiffs. The courts here, though, declared their injunctions universal and global and national nature, that any alien, whether or not represented in a given case, benefits from this. And the reason why these are controversial is people who have no connection to a given litigation can now benefit from the injunction. And these become fairly common in recent years, and over the last decade or so, they become pretty common. If you go through your rules of civil procedure, which I know you all love doing, there's no rule saying you can issue a nationwide injunction. Rule 23 of the Federal Rules of Procedure concern class actions, right? You may have gotten those little postcards in the mail, like, where Blockbuster Video charged you 15 extra cents on a rental 10 years ago, right? You can certify a class of people who aren't participating, but they still can benefit from it. But these litigations were not class actions. They were brought as just nationwide injunctions. So the upshot is you have district courts now who are exercising effectively global reach of their rulings beyond the people in their district, in their state, and beyond the people even outside the borders. And I think Justice Thomas criticized that heavily in his opinion. We'll probably see litigation over the nationwide injunction, I think at some point next year or so, because the effect of a nationwide injunction is it forces the courts to run to the Supreme Court for emergency intervention, right, if it's a nationwide in scope. If you have an injunction that's limited to just a small group of people, all right, so what? The government says, we'll protect people this place, but not that place. Now, I'll try and give the other side. Limiting an injunction in this case to a specific area would be problematic. So let's just say that a federal judge in Seattle issued an injunction. Okay, great. So if you're coming in through Seattle International Airport, you're good. But if you're coming through Dallas-Fort Worth, you can't. I think there will be significant administrability problems if certain airports have the travel ban, other ones didn't. So I don't know, and I go back and forth on this. I think if you ever have a nationwide injunction, this might be one place where it's appropriate. But I do fully agree there's no legal basis for them. The civil rules of procedure don't provide for them at all. So that was a long answer, but that illustrates a little bit. Does that make a little sense? Yeah. Yeah, but this is a very vigorous topic which people disagree on. District courts love them because they're all powerful, like God, right? I can just enjoy the entire world. They're called inferior for a reason. Our Attorney General got in trouble for calling the low court judges inferior, but people didn't get their inferior courts. Okay, our acting Attorney General, who is the real Pope. Anyway, it's okay.
I was drinking. I was listening to
My mouth is getting swollen, so I'm gonna keep going. Okay. I can only take Advil every 6 hours, so I'll be all right. I'll be right. Yeah, it's a bit, they gave it to me in a box. It was very cute. The Tooth Fairy, my goodness. 34 years of inflation? My God, this would be like a 50 cents, 75 cents? I don't know. What's the going rate for kids with kids? $1? What's the going rate now for tooth? $5? I got a quarter. $1?
I would never give my child $5 for a tooth.
$1, is that the rule?
$1, that's it.
What about for the 34-year-old tooth?
Probably $1.
Inflation.
12% per year.
Let's, okay, now let's go into the statute, right? So I want to go into, I actually want to just, I want to walk into this, and also calling people now, half an hour in. You're on freedom for long enough. I want to actually walk through the statutory issue because we learned in Youngstown, right? The court doesn't cite Jackson, or they do cite Jackson with Korematsu, but we learned in Youngstown that when we're looking at questions of executive power, a very important framework is the statutory scheme, right? We have Jackson's 3 zones, and when the president acts with his own executive power, and he acts with a direct delegation of authority, we're in the first tier, the first zone of Justice Jackson. And we learned with Youngstown that when you're in the first zone, that the courts have the least business poking around. And the court should apply the greatest presumption of deference to the executive. So even though the court doesn't actually cite Youngstown here, they probably should have, the entire first half of the opinion reflects this, right? So, oh goodness, who am I up to? Dusty, you next? All right, Dusty. So let's walk through the first statute, right? There are 2 statutes that are really relevant. Again, I don't think we've ever read statutes before, but Dusty, you just want to read the statute out loud, 1182F? Thank you.
Whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate.
Okay, thanks, Dusty. So, excuse me, how does the majority, how does Chief Justice Roberts read that statute?
Oh, you still with me? Sorry. He says that by its plain language, that statute grants the president broad discretion to suspend the entry of aliens into the United States.
Okay. Does that statute include any limits on presidential power?
I don't think not at the beginning of his opinion, he didn't discuss any limitations.
All right. Yeah. I'm sorry, got one time. So, don't raise your hand. I heard a voice distant. That's okay. You know, she's not. She came here Saturday night. She was not feeling as a trooper. She was really good. 8:30, I think you came by.
Yeah, you were, yes.
I was falling asleep at that point. 8:15. Yeah, but she was a trooper. Came by. Yeah.
You said some limits.
Yeah. Okay. Good. Yeah, that's what I'm asking. So are there limits for the president exercising this power?
Right. Anything that's not detrimental.
Not detrimental.
Yeah.
Okay. Keep going.
For a period of time. There's a time limit.
What's the time limit?
You don't know that. It's
Okay. So I think Marcus hit on a couple points, right? This is a very broad statute, right? Let's just go through it again. Dusty read it for us a minute ago, right? It applies not just to an alien, but a class of aliens. A class meaning a group. That could be a class based on a certain trait, maybe that they have certain criminal activity. That could be a class based on nationality, right? It could be a class based on maybe religion, right? Very broad language. And then what are the circumstances in which the president can deny their entry? If he deems that their entry is detrimental to the interests of the United States. Now, it's not If Congress makes that determination, it's if the president determines that their entry is detrimental to American interests. Again, Congress passes a statute. And when Congress passes a statute, they are delegating their authority to the president to make these proclamations. So keep reading, right? If he deems your entry is detrimental, he can issue a proclamation for such period as he shall deem necessary. Not 90 days, not 180 days, for as long as he deems necessary. Now, the fact that it says period means that maybe there's some duration, but it can be, okay, every 90 days we'll revisit it. Is this limited to times of war? Does not say that. Do you have to have a declaration of war maybe? Doesn't say that. Do you need to have any sort of hostility with a foreign nation? Doesn't say it. And then, look, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants. And I don't want to get too into immigration law, but there are lots of different categories of people enter the United States. Sometimes you enter on a tourist visa, maybe you enter on a student visa, maybe you enter on a work visa, right? Maybe you enter in a sort of a lawful permanent resident to stay here, maybe a fiance visa, right? There are different categories of visas. There's, God, a lot of them. I can't even count them, right? But this applies across the board. And not only can he deny their entry, he can impose on their entry any restrictions he deems appropriate. This might include screening, right? Have to provide information, right? So, Gerald, let me ask you this question. Why would Congress enact this statute? This is just giving the keys away, right? Because we know that Congress has generally the power of naturalization, immigration. Why on earth would Congress enact this statute?
Well, I think it had something to do with the fact that it was well, I would go with maybe the fact that the proclamation itself is 12 pages and it
No. Why Congress enacted the statute in 1954, 55, might be off in the year, right? Why would Congress enact the statute? Again, they enacted the statute in the 1950s, long before anyone, President Trump was in diapers at that point, right? Why would Congress enact the statute?
wasn't this.
Again, it was enacted in the 1950s, old statute.
But that was right after World War II.
Okay.
Yeah, that's what I was thinking. So you basically, isn't that what happened in
Korematsu?
Korematsu?
Well, no, Korematsu is by people already in the United States. These are U.S. persons.
Right, but isn't it one of those things where Congress will make a statute after presidents have already sort of done these acts, and then because they've done it for so long, I mean, the opinion makes reference to that. All these past presidents have.
Diana? Well, we don't know that yet, though, because, right, Diana, my question is, if you were in Congress in the 1950s, again, I know you weren't there, I wasn't born, you weren't born, right? Why would you enact this statute?
I think the same with maybe with Korematsu, the people were in the U.S. already, but maybe to avoid other nationalities.
Let me ask this question, Diana. When Congress passes a statute, does it mean that they are okay giving the president this sort of broad authority? By enacting the statute, does it mean that Congress trusts the president to exercise this really, really broad power?
I want to say yes, because it brings you the highest tier, the highest ebb.
Okay, Marcus?
Or the desperate in this time of national emergency.
Okay, well, if I told you there was no emergency, it's passed in 1955, the war had been over for some years. But Marcus, let me ask the same question, right? If you're Congress, right, and you enact the statute, are you demanding a lot of reasons from the president why you're going to let them deny entry? Does this require, maybe you pass a statute like this, right? The president can suspend entry for 90 days, then he has to go to Congress.
No, you trust the president with this statute. Very broad, you leave it at his discretion to define the limits.
Now, President Eisenhower was in office, right? President Eisenhower was a good president. But when Congress passes a statute, it's going to be around for a long time. And it just sits around there, doesn't it? Right? So, yeah, James.
Did it have anything to do with the Korean War?
Well, I'll give you the history, not that's in the case, but there's actually a predecessor statute that came before this that was actually a little bit more narrow. And in fact, this statute broadened the president's power. It gave him more. Adrian, was your hand up a minute ago?
That's what I was gonna mention that. It said that certain provisions enacted in the First and Second World Wars, that the content is taken verbatim from those.
Yeah.
From this particular enactment, and that those were specifically for war and national
Yes, ma'am. Yes, exactly.
Since that was probably the intent of Congress.
To expand, right? That even if there was no recognized declaration of war, the president could still exercise his power. Right? Think about it. If Congress had an earlier version of the statute that said you can deny entry if there's a state of war, right? And they pass a new statute without that limitation, that shows that they want the president to exercise his power even if there's no war going on. Right? Because again, let's say we go to Congress now, and Congress wants to amend this. I think of a couple ways, right? First, the president can suspend entry for 90 days at a time, then has to go to Congress for further permission, reauthorization. You do that. Or, if the president wants to suspend entry, he must show by clear and convincing evidence that an individual person is detrimental. Not a class of persons, but an individual person. In other words, he has to submit a report to Congress making a determination. You can make the statute very specific, but it's not. It's pretty open-ended. And the only condition is the president must deem aliens detrimental. Right? I saw a few hands fluttering. Yeah, Kyle.
So to the question of why Congress would grant the president so much power, I think it answers Justin's question about self-preservation. And also, I think what Jefferson was talking about, how we want a single executive that can be energetic.
Hamilton,
my bad. So that in situations that require immediate action, the president has the discretion to take it.
Oh, good. Okay, you stole my next point. Very good. So this is a very energetic statute, isn't it? It's saying Congress will pass general statutes to address things we can foresee, but some exigency may arise, and we want the president to be able to respond quickly, and not to go to Congress to reassess individuals in entry. Okay. Yeah. So, Kristen, let me ask you another question, please. What if Congress never enacted the statute? Right? Congress never enacted 1182. Never enacted it. Could the president block people from entering the country under his own inherent Article 2 powers if this statute was never enacted?
Are we talking still like the 50s or now?
I don't know. I'm asking you. I haven't thought that far.
Well, thinking in the time period, okay, let me do now. I guess now, technically, you could say we're in a state of war. So technically, you could say that, yes, he could enact that, right?
Well, but a state of war is enacted by Congress, right? Congress declares war. But I'm saying if there's no declaration of war, right? I'll give you an example. Forget airports, right? I'll give you an example, right, Kristen? Okay, so let's say the year's 1802. This is an exam question, right? And the Barbary pirates from Tripoli, right, are heading to New York Harbor, right? You have an entire horde of pirates. They were afraid of pirates back then. That was a big deal, right? Pirates are heading towards New York Harbor. We get reports that they're coming. And they want to invade New York Harbor. Could the president, Jefferson, send out a ship to intercept their ship and block them from entering the United States? Right? No declaration of war, but you have an incoming horde of pirates, right? Not like Johnny Depp, like bad pirates, right? Could the president stop them from coming into harbor?
I would say yes. It kind of goes with the preservation of self, and I guess kind of also what we're going through now, we're sending troops to the Central America.
You see where I'm going with this? Yeah. Okay. Good. Yeah.
So I guess yes, but I think eventually it's going to have to go through the checks and
But what power of the Constitution will allow the president on a sudden notice, he finds out the Barbary pirates are right out of the harbor. You got to make a decision now. You can't go to Congress. Congress is in recess, right? What provision of the Constitution, Kristen? That's my question for you. Oh God, you guys! Let her answer the question. Let me answer the question.
I don't know exactly.
Sergio, what do you think? I've called you enough. What provision of the Constitution will allow President Jefferson to deny entry to a horde of pirates coming in the harbor? Right, because everything has to come back from the Constitution. Shh. People read through the constitutions. I mean, you have Article 2, right? Article 2 is pretty open-ended. What would you look to?
Looking at Section 2.
What does that say?
Commander-in-Chief of the Army, Navy, and
Commander-in-Chief.
Militia.
Yeah. Does the president have the ability to respond to an attack without a declaration of war? Well, how do you know that? Does it say that?
Doesn't say that.
Right? And again, if Congress declares war, that's fine. But what if, again, the pirates invade? Can the president dispatch troops to respond to an invasion without getting an act of Congress? I think so. Right? So again, I don't want to dwell on this point too long, but the reason why I think the statute exists, Kyle alluded to it, is to have energism. That's not a word. To have an energetic executive, that if there's some sort of unexpected threat, to respond to it quickly, right? So again, if you have a horde of pirates coming to the harbor and they're seeking admission, there's no way that Jefferson will let them come in. I think we can all probably agree on that, right? So this statute reflects that the president determines that some aliens are are detrimental, he can stop them from entering the United States. But what makes this so different is it's not the president's responding to some exigency. Congress is in advance, prospectively, delegating a very big grant of authority to exercise his power. And it's not, oh my God, the pirates are coming, it's, someone's getting a plane from London or something, right? It's a different dynamic. Now, Clay, let me ask you a question, sir. What does detrimental mean? Detrimental to the interests of the United States? What does that phrase conceivably mean?
Just taking a negative manner, anything negative.
Yeah, I mean, anything negative?
Detrimental.
I mean, is there ever, wow, people just left at the same time. That's a bad question, right? Right? Is their exit is detrimental to the interest of this class, right? Right? But, Clay, let me ask you this question. Is there any case where something is not detrimental? I mean, is there anything where it's always good, 100% good? Right? I mean, literally, having one extra person in the United States, oh, whatever, maybe you have to deal with it now, right? You have some paperwork you have to process, right? You have to stamp his passport, whatever. That's detrimental, right? So, Janice, let me ask you this question. We talked about this once before. What's problematic about this statute in that the word detrimental is, man, that can mean anything, right? What's problematic about this act of Congress?
Well, it's too broad. It's too much discretion. I mean, you could basically define detrimental or frame detrimental in any convenient way.
So what constitutional doctrine is relevant here? Good review for the final. They all come in at the same time. Wow, look at that. That was impressive.
What constitutional doctrine is relevant here?
Yes, ma'am.
Can you be a little bit more specific?
No, if I get more specific, I'll give the answer away.
No, go give me the answer.
Who knows what I'm talking about?
I don't want you to give
Yeah?
the answer, but no.
I think you have Schechter Poultry in the delegation.
Yes, I am. Good job. Yes. The non-delegation doctrine. That's exactly right. And you recall, in Schechter Poultry, Congress enacted a statute that gave President Roosevelt the power to make fair labor codes, right? Without any guidance, right? It said, enact fair labor codes, whatever the hell fair means, right? You're not in my proper class. My least favorite word in the English language is fair, because it doesn't really mean anything, right? That's not fair, right? Little kids say it all the time. They have the baby tooth, right? It's not fair. Seriously, I felt like a 6-year-old because I had this gap between my teeth, cooking your tongue between it, like you're a little kid again. I had a good 5 minutes, and they started putting crap in my mouth. Yes, Mai.
I have some painkiller here.
I appreciate that. So do I. No, but I can't take them for 2 hours. So, thank you. Though. She has everything. She's got everything. No, I got around 9 o'clock. I'll take it. Maybe 9:30. I'll take it. That's class. Oh, vague. Stop. I'm good. I got doctors, lawyers, everyone. Okay, but Schechter Poultry. Schechter Poultry was a case in which Congress enacted a statute telling the president you can act fair codes of competition, and the court said in that case that's a violation of the non-delegation doctrine, right? Congress has to give the president principles, intelligible principles, to know how to implement the statute. My own opinion on this statute is it probably runs afoul of the non-delegation doctrine, but I'll say why it doesn't in a minute. Because it basically says you can block anyone from entering at any time for any period of time if you find that their entry is negative, and anything can be negative, right? you have to stamp some papers, right? There's no requirement of a state of war. There's no requirement of a showing of how detrimental it can be, right? Congress, I think, should repeal the statute, but whatever. It's been around for 60 years. But there's this. I'll explain why I don't think it's a violation of the delegation doctrine in a minute. There was a hand up?
No.
Okay. So questions on that? And I'll explain why in a minute. But as a basic level, right? Okay. Now, why do I not think it actually violates the delegation doctrine, right? Justice Thomas actually gives the reason in his concurring opinion. The Supreme Court has held in the 20th century that the president has an inherent power to exclude. This was my Jefferson hypothetical a minute ago, right? If Congress never enacted 1182, never enacted the statute, the Supreme Court, I think, would hold that the president could still deny entry to people who he deems detrimental. Now, think of Jackson. You're no longer in the first zone of Youngstown. You're in the third tier, right? You have zero statute, and you're relying only on the president's inherent independent power, right? So the reason why I think this doesn't violate the non-delegation doctrine under modern doctrines, it merely recognizes the power the president already has, right? It's not delegating anything. I think it's merely reaffirming the president's own power, which is why when you're in zone 1, I think it's fine. And I made this argument for the last year and a half. People think I'm nuts, but the court more or less reflected it. They rejected the non-delegation argument in the court. But it's a very, very broad statute, which I think Congress should revisit. I don't think it's a very good idea. And now, who asked me, Marcus? No, Kristen said it. The issue with the caravan, the president issued a proclamation like last Friday, a couple days ago. See, this class is always new, which I don't like making it a current events class. I hate doing that. Oh my God, my 2017 ConLaw class in January, it was impossible because everything was new every day, but it slowed down a little bit. But the same legal principle that allowed him to deny entry to aliens coming on planes, he now sought to apply the same statute, 1182, to the caravanners coming up from Central America. So it's the same exact principle. Now, that's not the only statute at issue. There's a second statute at issue here, right? Who am I up to? Adrian, please.
So you're saying you don't believe it violates because as commander-in-chief under Article 2, Section 2, he can respond to invasion.
Without a statute.
But then wouldn't that give credence to the fact that in this particular case, there was no major invasions? Because that implies as commander-in-chief, you're talking war. You're talking something major invasion, not...
Let me ask you, Adrian, has the president described the situation at the southern border? He uses the word invasion, which quite literally.
But
Yeah.
But Congress, the reports that came out stated the contrary, right?
Now,
So,
I can agree with you, right? We'll agree here, but what about the courts? Now, I'm going into the merits, but I want to just take Adrian's question briefly. She put a good question, right? What if the president says, he literally uses the word invasion, right? So I'm not exaggerating, right? It's an invasion. Now, can the courts second guess that? Okay, but I'll come back to about 20 minutes, I promise. I promise I'll come back. But I want to finish the statutory first, and we'll do the Constitution. Yeah, Michelle?
I just have one question.
Please.
On, you saying, I guess the theory that the statute is only reaffirming the power that the president already has. In that case, then why would they even pass it if he already has the power?
If there's any doubt about it, right? When you're talking about inherent constitutional power, not everyone agrees, right? In fact, Justice Jackson, in an opinion from 1951 or 52, wrote a dissent where he said the president lacks his power altogether. So even on the court, I think there was a disagreement of whether the president has his power at all. So I think, again, the reason why they passed is to reaffirm, yes, he has his power. And we agree. I saw a hand somewhere there-ish.
I'll raise one.
Yeah, Justin, then Quinn.
Isn't it true that we haven't formally declared war since World War II, I think?
Yeah, let me answer the question. So the question was, when's the last time we formally declared war? To have a formal declaration of war, yes, it was World War II. But we've had what are called authorization for use of military force. You might remember a couple of days after 9/11, you guys are probably alive, my one else probably weren't alive then, right? But shortly after 9/11, Congress enacted the 2001 AUMF, the Authorization for Use of Military Force. which allowed the U.S. government to use force against Al-Qaeda and those who aid and abet Al-Qaeda. Okay? And a year later, in 2002, there was a second AUMF against Iraq. Right? Now, the Iraq one doesn't really matter much, but the Al-Qaeda one is actually being used to prosecute the, don't call it war, but to prosecute aggression against ISIS and ISIL, right, in Syria. So it's expanded far beyond Al-Qaeda to other related groups. In fact, under the government's position now, I swear, Al-Qaeda is no more, but ISIS is the inheritance of Al-Qaeda, right? That ISIS filled the gap. There's a huge debate about whether the 2001 authorization covers ISIS. ISIS actually teaches, I don't teach it anymore, but there's a huge debate about that question. Yeah, Quinn.
For the president's inherent power to exclude, is that just persons or could it include other things?
Groups of people, yeah. Yeah, I think my final exam question 2 or 3 years ago, long before the president was elected, maybe it was last year, I can't remember, involved denying entry to, I think, the Germans or Japanese citizens during the war. I can't remember if it was last year, maybe it was. You can check me on that. Yeah, Clay? Oh, you're tipping your hat to me. Thank you, sir. Thank you. So this is the first statute, right? So again, it's pretty open-ended, but it does have constitutional dimensions. Now, the second statute is a little bit more boring, but very important, right? In 1965, Congress enacted a very famous Immigration Act. By the way, the 1960s was the most rapid period for the enactment of big laws. We talked about the Civil Rights Act of '64, remember with Title VII and Title II with the Heart of Atlanta and Katzenbach, the Ollie's barbecue case, right? We have the Voting Rights Act of '65. And in '65, Congress also enacted the Immigration Nationality Act. This was a huge law. And one of the aspects of this law was it radically changed our immigration policy. Before '65, American immigration policy was country-based. We had what were effectively called quotas, right? Where we would have a limit that X number of people from these countries could enter, and then Y number of these countries could enter, and then Z from this country, right? And the upshot is, from European nations, the numbers were quite high, and from poorer nations, the numbers were quite low. And you can do your math about which countries there were, right? The '65 statute said no more. We'll no longer have limits on immigration by country. Ironically, we have that now, right? Because if you want to get a visa from certain countries, you have to wait longer, right? So there's no cap. But if you want to come from one country, you have to wait years. Another country, you have to wait not long. But that's not because of a quota. And we have a statute, 1152, right? And it says, no person shall be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of origin. Notice religion is not on that list. If you read it quickly, you didn't even notice, but religion is not on that list. I'm sorry, what was that? No, okay. Okay. So you have the statute, right? Now, it only applies to immigrant visas. It doesn't apply to, for example, tourist visas or temporary visas. These apply to people coming here full time. So this statute doesn't put any limitations on denying entry to non-immigrants, right? But I think, Noel, I think you're next. How does the court reconcile the travel ban, which denies entry to large groups of people precisely based on their nationality of what country they come from? How does the court reconcile these two statutes?
Doesn't it say that they're different?
Okay, that's right. Why?
Because one takes effect regardless of whether you're at a point of entry.
What do you mean? I think you're on the right track, but tell me what you mean.
So, requesting a visa is not the same thing as entering.
Ah. So this is my contribution. By the way, the Chief Justice copied a lot of things I wrote without citing, which was very frustrating. But I was like the first person to make this sort of argument back in 2017. The statutes operate in different levels, right? 1182 operates on entry. Okay? 1152 operates on the issuance of immigrant visas, right? You may not know this, right? But when you show up at an airport, international airport, and you show up at the customs office, right? You're not on U.S. soil yet. You might have a visa in hand, but guess what? There's no guarantee you get in the country. I'll give you an easy example. Let's say you show up at an airport, you go to the customs office, and you have a really high fever. And you're coughing blood. And it turns out you have Ebola. Guess what? You're not coming to the country, right? Your visa's in hand, it's valid, you're getting put in a containment cell. You're not getting let in. And if you ever travel abroad, they actually have these thermometers. You ever see this? Where they sweep an entire room and they have these visual thermometers to your head temperature. You ever see this, right? If you ever travel to Asia, they have these guys with masks where they basically have a scanner and they check your temperature when you're crossing the checkpoint. If you have a high fever, you're not coming in because you might have bird flu or something else. So, with good reason, right? If someone's sick, don't let them in. Okay? What if you come to the checkpoint and they start asking you questions and they figured out that you lied on your application, right? That you gave some false information. Guess what? You're not coming in. What if they look at your picture and say, huh, this isn't you? In other words, you took someone else's visa and you tried to enter in, inaccurate. You're not coming in, right? Entry comes before the border, right? The people who are eligible to have a visa are those who are eligible to enter in the first place. In other words, if you're not eligible to enter, your visa is irrelevant. So they operate in two different spheres. And I wrote about this at great length. It's bizarre teaching about it. But the court more or less adopted that distinction. Right? Even though the 65 Act was enacted later in time, they're not in conflict. They're not in tension because they concern different spheres. So the court read these statutes not to be in tension. Now, almost all the lower courts ignored this. Right? All the lower courts said, of course, this is nationality-based discrimination. And the Supreme Court rejected it. And the dissent from Justice Sotomayor didn't even mention the statute. She kind of just walked past it. It was always a weak argument. But a lot of the lower courts said, aha, in order to avoid discussing constitutional power, we're going to rule in the statute. But in doing so, they gave a very narrow range. So some of the district courts said, well, we think that in order for a proclamation to be valid, there has to be a set time period, right? Well, the statute doesn't say that. And they said, in order for it to be detrimental, the president has to make specific findings of why an individual person is detrimental. Again, the statute doesn't say that either. So a lot of the lower courts read the statute with all these limitations that are completely artificial. It only applies for the state of war. It doesn't say that either. And these courts read statutes in completely implausible ways to avoid, I think at least, trying to rule in the president's constitutional powers. But the court moved past that pretty quickly. All right. Are there any questions on the statutory argument? You know, it's not nearly as interesting as the constitutional ones, but any questions on the statutory arguments? No? Okay. So let's talk about the constitutional arguments, right? Who am I up to? Quinn, you next? Okay. So Quinn, let me ask you this question. Who does the Constitution protect?
Citizens?
Only citizens?
Not sure.
Does it protect persons?
Can't think of a clause.
Oh, you can't think of a clause. Take out your Constitution. You can't think of a clause. Take a look at the 14th Amendment. Take a look at the Second Amendment. Take a look at the Fourth Amendment. Yeah. I mean, look, just walk through the Bill of Rights, right? Second Amendment, the right of the people. Fourth Amendment, securing their persons, right? Fifth Amendment, no person, right? 14th Amendment, equal protection, persons. Due process, persons, right? So, almost all the provisions of the Constitution protect not just citizens, but persons. Quinn, your follow-up question, persons where? What persons are protected by the Constitution?
Born or naturalized in the U.S.
Does the Constitution protect people outside the U.S.?
If they were born or naturalized in the U.S.
So if you're a U.S. citizen living abroad, are you protected by the Constitution?
I don't know.
So I'll give you an example, right? Let's say, Michelle, you join the military, right? You're working at a base in Japan, a U.S. base in Japan. And let's say your kids are living with you, right? Can the military police search your kid's stuff without a warrant?
No.
No, but you're not in the United States.
Well, but what I'm thinking of is, don't you get the protection based on you being, what's the phrase? Subject to the
Jurisdiction? Yeah, you may come back to that, aren't you? Yeah, very good. Thank you, Michelle. If you are a U.S. person living abroad and say you're in an embassy or military base and your family's there, they're still protected, right? We say that the Constitution follows the flag, right? That where the U.S. has a presence, U.S. persons get protected by the Constitution. But I said U.S. persons, right? What if you are a Japanese citizen who is, working on a military base, and the police want to search them? They're not protected by the Fourth Amendment, right? Aliens abroad are not protected by the Constitution as a general matter, okay? For example, if the U.S. government works with the Mexican police department and they conduct a search in Mexico and they find drugs, and they don't get a warrant from a judge, and the defendant is not a U.S. person, that's okay, right? The Constitution does not apply to a non-U.S. person. I'll give you another example. This one's actually a live issue now, which is going to the court this term, I think, or next term. What if you have a border agent on the U.S. border in Mexico who fires a bullet, and the bullet crosses the border and kills a person? Now, if a border agent fired a bullet in the United States and struck a person in the United States, citizen or not, you could sue him for damages. What if the bullet crosses the border and strikes a non-U.S. person? There's a circuit split on this exact question now, where the Fifth Circuit said that there's no implied cause of action, and the Ninth Circuit said, yeah, there is, you can sue. So I think the court will have to resolve it this year. But it raises the exact question, what are the constitutional rights to be free from search and seizure? Right? A bullet is literally a seizure of your person, if you think about it. Right? If you're shot, it's a seizure of your person. So why am I talking about search and seizure? Right? Why are we even talking about this up? What are the rights of non-U.S. persons to enter the United States? Or is it a right at all? The court calls it a privilege. Right? A privilege. Right? The fact that an alien can enter is a privilege, right? No one has a constitutional right to enter this country. But why is that important? If a person only has a privilege to enter, and they're not allowed to enter, how can they sue, right? So the plaintiffs in this case weren't actually the aliens seeking entry. They were U.S. persons, U.S. organizations, U.S. universities, states, who wanted to be reunited with their relatives, right? The reason why this case is in court is you had U.S. persons who wanted to be reunited with their relatives, and that's how they got into court. Now, Maya, let me ask you a question. If I were to tell you about this case where, let's just make up an example, this is obvious, right? The president says, I am signing this executive order because I want to punish Muslims and I don't want them coming to the United States. I just make up that up, right? Which provision of the Constitution do you think would be relevant?
I would say their 14th Amendment.
Okay, why?
Is under their equal protection.
Okay, good.
And I would go back to what is fundamental right of a person.
Okay.
And I would say that the president cannot discriminate or have a differential treatment toward a person on the basis of race. Oh, this is religion, I'm sorry.
Does the 14th Amendment protect aliens abroad?
It would not, but how about their relatives saying that they
But are the relatives being discriminated against?
in indirected way?
Oh, indirectly, okay. So Tim, let me ask you the same question, right? What provision of the Constitution, right? The example is this, the president says, no Muslims can enter, I don't like Muslims, right? What provision of the Constitution would you think you would usually sue on?
Well, in this particular case, I decided to go with the First Amendment establishment.
But which clause do you think is a better fit?
I think the 14th is a little bit better.
I'm thinking of another one. You know what I'm thinking of? No? No, it's in the First Amendment, the other one.
Oh, free exercise?
Free exercise. Thank you, Tim. Free exercise, right? Why? It's quite literally putting a burden on their free exercise. Because they're Muslims, they can't enter, right? It's a straight up ban on people in their religion, right? Now, why, Samantha, why do you think that the plaintiffs in this case didn't bring a free exercise claim? Simon mentioned in the book. Why do you think they didn't bring a free exercise claim here?
Well, the proclamation didn't explicitly state Muslims or religion.
Right.
There were, I think.
My question is a bit more basic, right?
Okay.
Do the aliens abroad have free exercise rights?
No.
No. That's the answer, right? This is like the Lukumi case, right? Right? They banned slaughtering of chickens, right? Remember that case I mentioned, the Santeria faith? It's free exercise. The reason why this is not a free exercise case is because aliens abroad have no free exercise rights. They can't assert them. No one's telling the American people here you can't exercise your religion. It's burdening the rights of foreigners, but not those inside the United States. But the Establishment Clause works differently. It operates as a structural provision. What do I mean by that? Well, Adrian, how does the court, let's go to the Sotomayor dissent just for a minute. She actually only talks about it, right? Why does Sotomayor think, people flipping, flip. You can flip, it's good. Flip. I'll come back to the majority in a minute. Yeah, why does Justice Sotomayor, Adrian, think that the executive order runs afoul of the Establishment Clause? And I don't need the specifics of the statements, but just as a general matter, what about it?
Well, I think she's saying, let me just go through her basic dissent was that the group, the nationality of the group was based on their religion, primarily Muslims, and that since the Establishment Clause does not allow Congress to forbid or make any laws that will forbid the establishment of a religion, then because of the president's previous comments of why he was attempting to exclude a particular group based on their religion, that the Establishment Clause would be the better case by which to argue.
So how does this policy establish religion? Does it?
The policy doesn't establish.
Why does this policy run afoul of the Establishment Clause according to the dissent? What specifically about this policy? Oh my God, she dropped the Constitution. You have to say 50 Hail Madisons after class, okay? I'm joking. I'm joking. No. It's okay.
Go back to the establishment. No, you're saying why the statute, right?
No, the executive order. Why does the executive order violate the Establishment Clause? That's my question.
Because his executive order stated, let's see, that the people from these specific countries were what he deemed to be a threat. But what Sotomayor was saying, that the rationale that was used was really created just to support the true fact, which was this group of people that all belong to a specific religious group. So that's why she argued that.
You're right. Okay, let me just take a step back. So here's what I'm looking for. Maybe it's not clear enough from the opinion. According to the justice, right, this policy expresses a disfavor of Islam, right? It says we disfavor Islam and we favor other religions. That is where she gets the Establishment Clause violation from. Everyone get that point, right? This is not saying that we're establishing a religion as a national religion. She's saying that if anyone, or not anyone, but if this policy would suggest that they're favoring one religion over another, or disfavoring religion, and under the Establishment Clause, disfavoring one religion over the other is itself unconstitutional. Now that's why they go establishment, not free exercise. It's not based on the infringement on individual right of religion. It's based on the policy the government chooses to favor one religion over the other. Everyone understand that point? It's actually a structural limitation how the government can act, not just with respect to people abroad, but in general. The domestic act assigned the executive order was itself an endorsement of one religion over another, or specifically a disfavor of one religion over the other, right? That's why this case is brought as an Establishment Clause case and not brought as a Free Exercise Clause case. Everyone get that much? Okay, now I just want you to get that. Okay. So now go back to Roberts. Flip, right? Oh, goodness. Who's next? I think it's Kenesha. I'm sorry. I already did this row. I'm sorry. I think. Does anyone else want to go? You want to go, Kristen?
No, I was gonna ask if you could repeat what you just said. This was it was not brought as what clause?
Free Exercise Clause. Because Free Exercise Clause is an individual right that one holds that their faith is not being burdened. This is brought as an Establishment Clause case because it imposes a structural limit on the ability of the executive branch to disfavor religion. Make sense?
Yes.
All right, Kenesha. I'll give you a question, right?
I'm trying to figure out how.
I did this middle last class, right? Yeah. I'm sorry. So let me ask you this question, Kenesha. Why does the majority, right? Why does the Chief Justice not think that the Establishment Clause is violated with this executive order?
Well, I gotta flip back.
Flip? It's okay.
So he said that the plaintiff's Establishment Clause claims were not justifiable because that clause doesn't give them a legally protected interest in the admission of foreign nationals.
Okay.
And so that argument depends on it would concern the merits rather than justifying their claim. So they said that the individual plaintiffs have Article 3 standing to challenge the exclusion of their relatives under the.
Okay, good. Jason, let me ask you this question, right? Does Chief Justice Roberts think that this case should be governed by the same standard as, like, putting a 10 Commandments in a courthouse or, school prayer? Do you think that the case is along the same level?
No, I don't think so.
Why not?
He said it was inconsistent with the.
What's unique, Jason? What's unique about the context in which the president issued this executive order? Right? Why is it unique in this context? What's special about this context?
Which context?
The context in which the president issued the executive order. Why is it unique? Why is it perhaps different than other Establishment Clause cases we've done before?
because it's not, the executive order is not establishing any type of, the state's not establishing a religion.
No, Delbert. Why is this executive order different than maybe some of the other Establishment Clause cases we've done before?
Because this is a national security justification,
Why does that matter?
because it's for the protection of the country. and of the
Okay,
people.
very good. Thank you so much. So a threshold disagreement between the majority, Justice Roberts, and Sotomayor in dissent, they don't even agree on the correct standard at all, right? There's a footnote where Justice Sotomayor explains it. She says, we should apply our usual Establishment Clause case law, which we'll get to in a few minutes, I promise. And Roberts says, no. This is different, right? This is not like putting a 10 Commandments in the courthouse. Right? This involves national security. This involves the sovereign act of denying entry to aliens, right? If you apply the court's traditional Establishment Clause cases, it becomes a very easy decision. But if you don't, it goes a very easy decision the other way. So Drew, let me ask you this follow-up question. Why does the majority think that you shouldn't apply the Establishment Clause, the regular version, heightened scrutiny to these facts?
They brought up regarding presidential deference.
Yeah, okay, bingo, D word, right, deference. Well, explain what that means. Give me a little bit more.
They have one line here where they said, when the executive exercises the delegated power negatively on the basis of a facially legitimate and bona fide reason, the courts will neither look behind the exercise of that discretion nor test it by balancing its justification against the asserted constitutional interest. So really, I mean, they're kind of giving, I think we brought up earlier the energetic executive, really, giving the president the power to execute on the statute.
Yeah.
Not scrutinizing his.
Okay, let me ask you one question, Drew. You're on a roll. Why do you think the court doesn't want to scrutinize this exercise of president power, in particular in the foreign context? Why are they hesitant to exercise that sort of scrutiny?
I would say maybe they don't know what's going to come up in the future.
Ah, right. Okay. And let me address this point very broadly. You guys laughing?
You get excited.
What?
You get a little excited sometimes.
Well, people give a good answer. I get excited.
Oh,
Well,
I love it.
if you haven't figured out what I do right now, I'm looking for a specific answer. And I keep asking damn questions till I get the answer I want. So when one person gives me the answer I want right away without going through 5 people, it's like pulling teeth sometimes, right? Yeah? Although this is not painful, right? But when I get the answer, I just say 5 minutes, right? So I can now move on. Right? I mean, that's what I'm doing. I want a question that gives a specific answer, and he gave me what I was looking for, right? I was like, oh yeah, that's what I want, right? So, good job, right? So, the court is basically saying here, I think Roberts addresses this, the present situation with President Trump might be a case where we could probably apply some scrutiny to it and say that this is probably not the real reason we have this order. But setting the precedent of closely scrutinizing foreign policy executive action could, down the road, impact another president who maybe has more pure motives, to put it gently. And there's this one sentence, and I was actually in the court when Roberts announced it. And the second Roberts said this, like, okay, Trump won. I didn't know, because Roberts never tells you the outcome of the beginning. He always drags, like an Obama, he drags you along, right? And I was like, oh, okay, Roberts has it. And he said, this case is not only about the president, it's about the presidency. And as soon as Roberts said that, I'm like, oh, okay, I know which way this is coming out, right? Because I was seeing there, the way it works is when you're in the Supreme Court, they say, Chief Justice Roberts has the opinion in Trump against Hawaii. They don't give you a printed copy of the opinion. You sit there and you listen. And he actually reads from his opinion, but Roberts never gives you the damn holding till the end, or at least the middle. So I didn't know which way it was going. I had no idea which way it was going. But once he said, it's about the presidency and not this president, I'm like, oh, I know which way he's going on this one. Okay? Now, Kyle, let me ask this question, right? What case have we done before, and we studied this case pretty early in the semester, that might cast doubt on Drew's answer about deference, right? What case are we thinking of here? that deferring to the executive's assertion of national security on an executive order.
Merriman? Is that what we're
Oh,
talking-
Merriman.
suspending the writ of
A little bit more recent than Merriman.
Korematsu?
Okay. What was the court scrutinizing the exclusionary order in Korematsu? That's the justification. Or they defer?
They deferred in Korematsu. And it was the same reason, basically. Like, you need to let the president handle national security matters.
And you remember Justice Jackson had an opinion, which is actually cited here, a dissent in Korematsu. And he said Korematsu's opinion like a loaded weapon, right? He had this God, Jackson could write. It's like a loaded gun, or a loaded weapon that just sits around until someone picks up and shoots it, right? So there are two sides to this, right? And again, I always want to give you both sides of every picture. On the one side, the court says we don't want to set a precedent whereby we closely scrutinize the president's assertions of executive power in the future, right? On the other side, when you defer, you set a very different precedent, in one which the court will not scrutinize a blatantly biased order, which, I'll get to second age, I promise, which then leads to Korematsu, right? So I was sitting there in the court, and I was like, okay, I guess the president won. Well, it was whatever, I was ready to go. Then he says, Korematsu. I'm like, oh crap, you mentioned Korematsu. Let me tell you something. Korematsu was not mentioned once during the oral argument. The lawyer for Hawaii didn't mention Korematsu in his brief at all. But let me tell you, it was in the background. It was floating in the background. And then Roberts goes, oh, what's the quote? The court of history. I want to make sure I get the quote right. What page is it? Thank you. I want to make sure I just read this right. Because when he says, like, whoa, where the hell did that come from? Like, I was actually surprised he went there. There it is. Thank you, 63. So he says, the dissent's reference to Korematsu, however, affords the court the opportunity to express what is already obvious. Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law under the Constitution. And when he said that, I was like, did he just quote Jackson? Because I don't have citations in when he's saying it orally, but I knew the opinion. I was like, well, he just quoted Jackson, didn't he? And then wait a minute, whoa, what just happened here? The court can't overrule precedents in the abstract. It's not how this stuff works, right? You can't say, oh, we don't like this case anymore. So it's only ruled in the court of history. But what he's basically saying is, we reject, right, Korematsu's use of deference. But then Sotomayor responds, here you're adopting a very similar strand of deference to the executive. So, yeah, I was actually shocked when that happened. There's not many surprises in the Supreme Court. This was a big surprise. All right, I think I'm done with the majority. Yeah, Adrian, yeah.
So, you said that there was two sides to this. The first side is you don't want to set a precedent that would too closely scrutinize the decision. But on the other hand, if you defer to the president, you risk giving too much power.
The loaded gun.
The loaded gun.
Yeah.
But why wouldn't they err on the side of scrutiny? Because so the framers could not have anticipated what we're dealing with right now. It's just think people are going to follow the rules, right? And so if they defer, closely scrutinize, if the executive intent is appropriate in order, it should the strict scrutiny, that it should come out where it passes strict scrutiny, and then they wouldn't have to worry about it. But you have a check. Allow the strict scrutiny to be the check. Why go so far to the other end? To me, you risk more by giving the loaded gun than you will just strictly scrutinize it, because the motivation would come out, or the intent, and it could pass if it's decent and in order.
Yeah, everyone understands. Yeah, I think it's a fair point. So let me frame this in terms of our semester. We've had presumptions, right? You have presumption of constitutionality, and you have what you call presumption of liberty, right? And we've had this discussion a number of times this semester, right? Why in some cases the court apply a presumption of constitutionality? They might decide that the elected branches might know better than we do. And whereas presumption of liberty, if there's a specific act affecting U.S. persons, you maybe have heightened scrutiny. But when it's people abroad, which is why I made that long discussion, they don't get the presumption of liberty. They get basically a rational basis review. So I think, and Adrian, I think framed your question very well. I think the short answer is the court said we're going to give a presumption of constitutionality here, a presumption of what you might call regularity, right? That the executive is acting in a regular fashion, and we're not going to scrutinize and second guess what's going on. So they better have the loaded gun sitting around than having judges demand access to classified briefings on a daily basis. I was actually at the Fourth Circuit oral argument in Richmond, Virginia, for one of the travel ban cases, and one of the judges actually asked the government to submit a classified report to the court. And the lawyer's like, no, we're not going to do that. Now, should judges demand that? If they had demanded that in Korematsu, they would see that there's really no threat, right? It's a very precarious balance. This is not an easy question. And the Supreme Court said here, at least in the foreign policy context, you err on the side of constitutionality. Now, that doesn't extend, I think, to all contexts, because if the travel ban, I'll go back to the caravan thing, to the extent that people are already in the United States, I think then they get the full panoply of Bill of Rights. But if they can never enter in the first place, and there's denied asylum outside the United States, I think they're in the same space as the travel ban people. If they never get into the United States, they don't get our protections. I don't assign the Guantanamo cases anymore, right? But the huge issue with Guantanamo Bay is Guantanamo Bay within the United States? Does our laws extend there, right? And it goes into the specifics of what is Cuba, what's the relationship to Cuba, complicated, don't want to go into that, right? But the court ultimately held that Guantanamo Bay was under our power, under our control, therefore habeas corpus goes to Guantanamo, and the detainees there can avail themselves of the court. Nothing happened since. The court sort of just gave up after 2008. But that was what happened. Yeah, Aaron?
You said that if they enter into the States, then they're entitled to our same rights, but if they don't enter, then they're not, regardless of what their citizenship is or whether they're alien or not.
Are you talking about the travel ban or the caravan now?
Just in general.
Well, if you're in an airport customs area and you didn't clear customs, you do not get our rights yet. You're still on international soil, right? I'll give you an easier example. In the early 90s, you might remember the Haitian boat crisis. Remember this? This was a huge thing back in the 90s. You guys, I don't remember it. And you had basically these boats coming in from Haiti. You had the same thing with Cuba as well, right? And if they made it to U.S. soil, they were good. If they were intercepted at sea, they were not, and they were turned around. In fact, for years, we had a policy with Cuba called wet foot, dry foot. You know about this? Where if a Cuban made it onto the beach, he got protection. If they intercept him at sea, he got turned around. So the territorial aspect of it actually makes a huge difference of where you're intercepted. And specifically, if you're at an airport in the customs area, you're not on U.S. soil yet until you clear customs.
So what if you enter the country illegally, where you have those rights still entitled or not?
Yeah. So I'll just briefly explain. Usually with the asylum, you have to enter through a port of entry, right? The people claiming asylum, if you go to a checkpoint like in Tijuana, near Tijuana or near like Laredo or near Brownsville, right? It's a port of entry. If you cross the border in like a desert somewhere, you're not entering through a port of entry, so you don't get the same sort of protections. But you can claim it in the interior, but it gets more complicated. Immigration law is so complicated, my goodness. It's really, I've had to have a crash course of immigration law. It's very complicated. All right, I want to make sure I finish on time. Are there any other questions on the Chief Justice's opinion? Sergio.
So just maybe this is a dumb question.
There are no dumb questions.
What's the Korematsu standing, man?
Red flag. I think Westlaw put a red flag on it that day because they would want to be cute. But, I mean, if you're citing Korematsu in an opinion in a brief, your brief should probably be edited a little bit more. I think there are other... Well, but this is not a joke, though. During the Guantanamo cases, there was a huge debate in the Bush administration. Did they cite the Korematsu case? And I think they cited Hirabayashi, right? The government cited, remember, Hirabayashi was the curfew case. And I believe, don't quote me on this, but I believe the government cited Hirabayashi, and they were okay with that, but they wouldn't cite Korematsu. No, Hirabayashi I think is even worse than Korematsu in some respects, right? But anyway. All right. I'll do Kennedy, right? I think I don't know if I mentioned this, but the Kennedy retirement. So we all know that Justice Kennedy retired last June. He's now been replaced by Justice Kavanaugh. I was in the court on the very last day of the term. And there were all these rumors fluttering. Will he retire? Will he not retire? And I was talking to a bunch of the Supreme Court reporters that morning over breakfast. And they're saying, Josh, what do you think? Like, I don't know. What are you asking me? I have no idea. They all ask me anyway. They think I know things. It's hilarious. I don't know anything. They always call me when they want to know stuff. I don't know a damn thing. The Supreme Court reporters were asking. So then we walk into the court. And the way it works like this, right? Let's say the bench is the back row of the room. On this side is the press box where the reporters sit. And this side is where the family members sit. And the attorneys sit up front. It's called the bar because there's actually a bar. And if you're a lawyer, you can cross the bar and there's nice reserved seating. Otherwise, you're stuck in the back. So I always sit near the press section, right? I'm always sitting there. And then they always have a hobby where they watch the family members of the justices come in, right? And then so, Justice Breyer's wife walks in. Okay, whatever. Justice Alito's wife walks in, whatever. Then Justice Kennedy's wife walks in, like, uh-oh. And then Justice Kennedy's son walks in, like, uh-oh. And then Justice Kennedy's grandkids walk in. And one of the reporters actually says, oh, F. And she said the word. Because, like, uh-oh. Why is his entire freaking family here? And think, oh, crap, he's retiring. So I'm sitting there, and going through the opinions, and they do the travel ban, everything else, whatever, right? Oh, no, travel ban wasn't that day. Other case was that day. And at the end of the sitting, Chief Justice Roberts goes, I have some retirements to announce. I'm like, oh. But he doesn't mention Kennedy's name. And he mentions two names, and the names didn't mean anything to me. I'm like, whatever. What I didn't realize is one of the names he mentioned was Justice Kennedy's executive assistant, who they announced her retirement. And I didn't know the person's name. So I'm like, oh, okay, whatever. So I leave the court, and I actually went with Randy to record some videos. And then as I'm in the car ride, I was doing a radio interview. I said, well, just wait till the end of the day before maybe he'll retire or not. And then he retires like 20 minutes later. So he retired. But Tony Kennedy, right? We call him Tony there, right? Tony Kennedy's last act as a justice of the Supreme Court was writing his concurring opinion in Trump against Hawaii. That was his last act as a justice. And, we can scrutinize as much as you want. It doesn't really matter what he thinks anymore. But I do think it's worthwhile studying briefly. Who am I up to? Ross, walk me through Kennedy's opinions. Only a couple paragraphs, real short. I mean, he had a lot to say in his career, but he sort of just went out with a whimper here.
So he begins by talking about that there is some common ground between the opinions in the case.
Mm-hmm. Romer, his favorite case, right?
Continues on to say that there are also some types of government officials that are not subject to judicial scrutiny.
Okay, that's the exact sentence I want to talk about. Thank you. He says, let me read the sentence. He says, there are numerous instances in which the statements and actions of government officials are not subject to judicial scrutiny or intervention. Ross, what the heck is that? After an entire semester of ConLaw, right? You studied all Lawrence and Obergefell, right? And Windsor. And my goodness, Justice Kennedy scrutinizes everything. Ross, what the hell is that?
I don't know, maybe a farewell gift.
Yeah, farewell gift, maybe. Jesse, what do you think? Anyone want to take a stab? Well, all right, Marcus?
Sort of along the lines of why Congress would actually enact the statute. Right? I mean, with the president that discretion to use that power whenever he sees fit. We should question whether or not reasons why.
Okay, Kristen, your hands up?
I think it kind of goes along with his next sentence where he says it doesn't mean that those officials are free to disregard the Constitution.
Uh-huh. Oh, good.
I think he's kind of just saying, like, sometimes these officials are going to do what they're going to do.
But what's the check?
Oh,
That's the question.
it's kind of, well, personal opinion, I think it's got to be like a self-check because he talks about the oath that they take, and so it's kind of
Good.
got to remember your morals.
He says, indeed, the very fact that an official may have broad discretion, like this statute. Marcus is right. The very fact that they have broad discretion, discretion free from judicial scrutiny. This is not rational basis scrutiny. This is no scrutiny. This is zero scrutiny, right? Makes it all the more imperative for him or her to adhere to the Constitution and to its meaning and its promises. But what if he doesn't? What's the check? So Jesse, what is the check then, right? What if there's no judicial scrutiny here? What's keeping him honest, right? What's preventing them from doing what the hell they want? It's not the courts. What is it?
The people.
How so?
I would say if he does, then the people bring it up. The people.
What do they do every 2 to 4 years?
Re-elect.
They vote.
Vote.
We just had an election 2 weeks ago, which I think was in large measure a repudiation of a lot of stuff that's been going on, right? That's what Kennedy's saying. After all these years, what? It is. It's so out of character. Oh my goodness. When I read this, I was like, holy shit. I'll just say it. I think I let it across like, Kennedy? Did Kennedy, after this dignity crap for 3 weeks, all this, we're going to declare the marriage laws in 38 states unconstitutional overnight? What he's saying here, and I don't know what got to him, but he firmly believes here that this is a case where the political process will be the check. And that politicians have to adhere to their oath. And if they only adhere to their oath, it's up to the political process and not the judiciary to check it. Which again is completely out of character with everything he's read the last 30-something years. And I want to make this point bluntly. Shortly after he wrote this opinion, he announced his resignation, retirement, to give President Trump the chance to replace him, knowing full well that the president would nominate something to his right and move the court in a more conservative direction. This is what I'm saying is I'm okay with this, right? You have to view those two acts in tandem. In the same week that he ruled in the travel ban case, he announced his retirement, giving the president the chance to push the court to the right. And he picked his law clerk, Brett Kavanaugh clerk for Kennedy, as his replacement.
So you're saying he wrote this so that even though he knew the court would become more conservative, that the power shouldn't even be within the court?
That's one theory. I don't know why. That's a good theory. I mean, his last sentence, let me read this. He says, an anxious world must know. God, I hate him. His writing, he's such a bad writer. An anxious world must know that our government remains committed always to the liberties the Constitution seeks to preserve and protect, so that freedom extends outward and lasts. I don't know what, I don't know. Your guess is as good as mine. But he was ready to go. He retired that next day, and he wrote this opinion. And I was like, wow, that's one way to drop a mic, right? All right, but anyway, I only have a couple minutes left. I'll make sure I get to the dissent. Any questions on the the Kennedy, I'm already jumping ahead, the Kennedy opinion? Oh, I just been muttering about Justice Thomas.
I'm sorry, I said he was an idiot.
Oh, come on, no. You gotta use law words. Don't just use words like that. So, I'm sorry? Why? Use nouns instead of I'll give you one tip, right? Don't use adjectives to describe things. Use nouns. I use that in my books when I write. When you use an adjective, it lets you be lazy. It's like, oh, that's stupid, right? Why? If you use nouns, it's incorrect because you failed to consider X, Y, and Z. You're actually giving me an argument. So if you write briefs, don't just say that's wrong. Why? All right. Yeah. So I only use nouns. I try. I'm sure I do. I fail, but I try when I'm writing at least not to use any adjectives and adverbs too. Adverbs are just the same. It was poorly reasoned. Why? Right. That's saying it's poorly reasoned. It's not an answer. Right. Kennedy writes poorly because this thing doesn't make sense. So let's talk about Thomas for a minute, right? Thomas said a few things in a very short span, right? One, he argues that these universal injunctions are not proper, and I don't want to go too far into that. Second, he argues that the Establishment Clause has a very limited meaning. I think I mentioned this last class. According to Justice Thomas, it only prevents the federal government from establishing a national religion or interfering with state religions. It doesn't affect endorsement, right? So he would basically jettison most of our establishment clause case law. Thomas also says, and I alluded to this, that the president has inherent authority. The case he cites, United States ex rel. Knopf versus Shaughnessy, 1950, is a case where the court said the president has inherent power to exclude. So even if 1182 was never enacted, according to Thomas, the president could do this anyway. Jackson wrote a dissent in Knopf where he said there's no such power, which I think is Michelle's question a minute ago. Not everyone agrees on this point. Only Thomas adopted that. All right. Questions on the Thomas dissent, or sorry, Thomas concurrence? By the way, no one else joined him, so it's just his usual solo dissent. It's his usual spot. He's now the senior associate justice. He sits right next to the chief at this point. He's been there the longest now. Yeah. No. That's an adjective, ma'am. Because. Thank you. Okay, if you give me a because, I'll let that one slide. All right, let's talk about the Breyer and Kagan dissent. Again, I actually thought this case wasn't going to be 5-4, and I was kind of right. The statutory arguments are very weak, and there's a very good argument why the Establishment Clause doesn't apply. But Breyer and Kagan went off on this sort of side tangent about waivers, right? So let me explain this briefly. I don't have a lot of time. Under the travel ban policy, the executive branch has the discretion to issue waivers, right, based on hardship. And Breyer says, okay, look, if you're actually handing out these waivers in a consistent fashion, that suggests that the policy is working as designed. But if you're not actually giving waivers, it suggests that the waivers are just a cover to make this policy seem more reasonable. And if it's just a pretext, that means it might in fact be an endorsement of animus, right? Basis, we don't know, right? And we can't decide here. But based on a limited record here, I'm going to say that is bad because the waivers have been proven to us. Breyer would say, send this back down to lower courts and ascertain, are they actually giving the waivers out in a fair fashion? Now, he dissents, but it's a very weak dissent. It's not an actual, I don't know why it's a dissent. It should be concurring in judgment, but he couldn't bring himself to go that far, so he dissents. Now, what happened afterwards, right? Nothing, right? I can tell you that the lawyer who argued this case at a law firm called Hogan Lovells, a very big law firm, they're not even litigating the waiver issue. They just let it go, right? All the energy in this case disappeared the second the court upheld it. It's not, I mean, I've looked into it, just it's nowhere, right? The courts aren't really doing anything about this. So at least as long as President Trump's in office, this policy will remain in effect. Yeah, Kristen?
So with that, so the courts have let it go, but so if I fly from Sudan, I can't get in?
Well, you're a U.S. person.
Well, no, I'm saying like hypothetically, like so this is still in effect.
If you're a Sudanese person,
yeah,
you are subject to the travel policy, yeah. You can seek a waiver, a hardship waiver. Maybe you'll get it, maybe you won't, but yeah, you can't come in.
But they could come off the list if they...
Yes. Yeah, and in fact, they made a big deal. Chad, which is an African nation, was on the list, and Chad was dropped off at some point before the case was argued, which was very well timed, to show that, in fact, countries can be added and dropped. I don't know that any countries were dropped since. I mean, you have like Iran on there. That's not going anywhere. You know, you have Libya. That's probably not going anywhere. Syria is probably not going anywhere. You know, Yemen. Yemen's a rough spot. Probably not going anywhere right now. So that list is probably going to stay at least for the rest of the presidency. I've got 5 minutes for the dissent. Oh, goodness. All right, any other questions on the Kagan-Breyer opinion? All right, let's talk about the Sotomayor dissent. You know, to read the dissent, it's as if you have a completely different case, right? You know, usually you might have the majority in dissent, they agree on certain things, and they have, you know, small disagreement. It's like they're writing about a different world here. And the Sotomayor dissent argues that, I'll read it, the majority misconstrues our precedent and turns a blind eye to the pain and suffering the proclamation inflicts upon countless families, individuals, many of whom are U.S. citizens. And she says, because the troubling result runs contrary to our Constitution, I dissent. Not I dissent respectfully. It's the mic drop. I dissent. And let me tell you, I was in the court when she announced this opinion, and she was very upset. The tone of her voice was anger, not like just disappointment, but like anger. And the way she said Trump, I was like, wow. But it was a very, very, very passionate dissent. And she read for almost, the dissent, I think, is the same length as the majority, maybe a little bit longer. And she read for about 15 or 20 minutes from the bench. So briefly, Dana, just walk me through at a high level, we only have a couple minutes left, the Sotomayor dissent, just high level. We don't have that much time left.
She says that the majority only tells half the story.
Okay.
And she goes on to log basically Trump's Twitter account.
Yeah, right?
And, she's upset he never disavowed any of his prior statements about Islam. Says majority applied a watered down legal standard.
Okay.
She says it doesn't matter that they include countries like North Korea and Venezuela. It's all a facade of what they're actually doing.
A facade. What does that mean, a facade, Dana?
Like a smoke screen.
Oh, good. Give me another good adjective. But what does it mean with a smoke screen? What does that mean?
It means they're doing one thing, saying they're doing one thing, but actually doing something else.
Okay, bingo. Okay. So Sotomayor would treat this the same way we've done the animus cases before. So, for example, Romer, right? Was Romer the amendment in Colorado enacted to ensure there were stable working conditions for businesses, or was it designed to show a disrespect for gays and lesbians? Windsor, right? Was Windsor designed to make sure that people married in one state moved to another have an easy choice of law question, or was it designed to express a moral disapproval of homosexuality, right? And in all those cases, the court said that, maybe there was some good reason why, but when you have this bare desire, this animus to harm, that's enough to declare it unconstitutional. If you notice, there's bleeding, right? Is this due process? Is this equal protection? Is this establishment clause? It's all animus. It's all Tony Kennedy's world, except Kennedy was on the other side. And that is what this case portends. Without Kennedy, almost all the gain for the left wing of the court would just not exist the last 20 years. They wouldn't be there. And because Kennedy voted with the majority here, it was just a dissent. How easy would it have been for Kennedy to write the Sotomayor dissent? You can read it, right? You could write it probably for your legal writing memo, right? Could you predict what Kennedy would write, how this denies the dignity of people, right? It's an affront to them. I do think that the tie-breaking decision is this involves the president and not local government, and also that this involves foreign policy, not domestic. I think that's why. But even then, he softened. In the Guantanamo cases, Kennedy ruled against President Bush. So something, he came to his conclusion for reasons I don't think we'll ever know. Maybe we'll get his papers in some years, but he came to his conclusion. One last point on the scrutiny question, right? The court actually says that the president's Twitter is not relevant. But because the Solicitor General, the government lawyer, asked us to, we'll consider it. That's an important point. The court says that the appropriate standard review is basically below rational basis, right? As long as it's not facially insane, we're going to uphold it. But the Solicitor General said you can look behind the curtain. You can peek behind a little bit. And he peeked behind and said, well, you got all these bad tweets. We got them. But you have this report from the government, and that's enough to sustain the policy. And because you had that government report and that policy, it sustains it. Now, would this policy ever come about but for President Trump's promise in the campaign? Of course not, right? But you were able to then uphold it after the fact because this report was created, which still had the effect of excluding people from predominantly Muslim nations. So where does this leave us? The policy has now been in effect for about 11 months or so. You don't hear about it in the news anymore because now we're on the next one, which is now the caravan travel ban, the asylum ban. I don't have a name for it yet, right? I get calls from reporters like, what? What do I have to talk about now? Birthright? What? I swear, I woke up at 5 in the morning and the reporter's like, can you talk about birthright citizenship now? It's like these frantic phone calls. Like, okay, fine. But it's always something new. All right, I have 2 minutes left. Whew. All right, questions on the Sotomayor dissent, on the majority?
I have a question. So
Please.
If you took out 01 and 02, so we're just looking at 03, and it were some other president who didn't, let's say, articulate such an animus against a particular religious group, there would be any controversy?
No doubt whatsoever. And Hawaii conceded that if another president signed Executive Order 3, it'd be perfectly fine.
Yeah, seems that way to me.
But only because of think of McCreary County, right? There were 3 displays of the 10 Commandments, right? The world is not born anew every day. You remember the previous displays. But Robert says that McCreary County doesn't apply. You don't apply the traditional domestic establishment clause cases. Anyone else? I will see you in class a week from today. I'll have office hours. If you want to come by before or after next week. But I'm going to the airport now. Thank you.